One of the best ways to reduce stress during a divorce, both for yourself and your child, is to try and get a child custody agreement without court processes determining the details. Curious to know how to reach a child custody agreement without a court? Carry on watching for everything you need to know. Consider informal negotiations. If you and your ex are on speaking terms, you might want to consider conducting informal negotiations. This typically works well in situations where there is little animosity and a lot of mutual agreement on what is best for the child or children. During informal negotiations, you and your ex-partner will need to come to an agreement over things like custody and visitation rights. You should also hash out things like where the child is to spend birthdays, holidays, Christmas, etc. Once you have agreed on the details, you can then go ahead and draft an agreement together. Alternative dispute resolution. ADR is a relatively new framework that covers a range of processes for resolving disputes outside of court. Through ADR, you can negotiate a parenting agreement either with the assistance of attorneys or without. While you can, and usually should, have a lawyer present, ADR typically tends to be more casual and less combative than court settings. ADR is generally best suited to couples who, while unable to reach an agreement on their own, still have some desire for cooperation. It is also an attractive option if you want to limit personal issues from being put on public record. The two most common types of ADR are collaborative family law and child custody mediation. Create a parenting plan. Whichever path you choose, whether that be informal negotiation, mediation, or collaborative law, the final outcome needs to be a parenting plan. A parenting plan is basically a proposed custody agreement drafted by you, the other parent, or any professionals involved, such as a mediator or your respective attorneys. As mentioned, this should include the details relating to the shared custody of your child. It can be as short, long, simple, or complex as needed. What details are stipulated in the agreement ultimately depends on your unique situation and requirements. Out-of-court agreement. Once you have reached the point where you have created a parenting plan, this out-of-court custody agreement needs to be signed by a judge to make it legally binding. When you submit your parenting plan to the court, the judge will go over it and determine whether it is in the best interest of the child. If so, they will then sign it. Once this happens, the custody agreement becomes a court order enforceable by law. In other words, if you or the other party breaks the agreement, this can be punishable with jail time. In almost all situations, reaching a child custody agreement without a court case is the best route. Not only is it cheaper, but it can also reduce emotional stress and foster a better avenue of communication between you and your co-parent in the future. However, it is also important that you have the right assistance in this process. Signing an agreement without the aid of an attorney can lead to trouble down the line.
Contact Patent Law Office for a consultation. And if you enjoyed this video, be sure to like, comment, and subscribe.